Good day, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk, the most fact-driven, unbiased true crime channel. All right, why are we here today? Live at 10:35-ish, here, I guess 10:31. Today on Wednesday, June 9th. Well, we're here because there is a scheduled arraignment for Chad Daybell on the indictment. Now, as what has taken place many times in Idaho is that it seems like there will be a in-chamber conference or something that's done on in the back office, so to speak, on Zoom, and then they come out and they recap and they tell everybody that's going to get continued. So the question now becomes, what is going to take place? Is the defense going to seek a continuance, or is the arraignment actually going to go forward, start that speedy trial clock that we discussed last night on our live program? So if you haven't watched that, I kind of explained the whole timeline and process in speedy trial. The state would have 6 months from today's date. So they basically have until December 9th to get him to trial. So that's actually a very short time. We'll see if the defense is going to say they need more time. Short of the allegations regarding the death of Tammy Daybell, it would seem like the defense would have been in possession of most of the discovery over the last year, so there really shouldn't be any real need for it. Additionally, the case isn't going to be slowed down in this regard, is because Lori Vallow has been, sent off to the state hospital for evaluation and restoration for competency. So today is the arraignment. And just a quick recap for those who maybe haven't seen the indictment. I'll give you a quick summary of the charges. Count one is conspiracy to commit first-degree murder. And Chad Daybell is listed in count one as a co-conspirator, and that's regarding the death of Tylee Ryan. Count two is murder in the first degree of Tylee Ryan. Count three, conspiracy to commit murder in the first degree. That's in regards to the death of J.J. Vallow. Count four, murder in the first degree for J.J. Vallow. Count five, conspiracy to commit murder in regards to the death of Tammy Daybell. Count six is first-degree murder of the death of Tamara Daybell. Count seven is the only count. It's a count where only Lori Vallow is mentioned, and that's in regards to the theft of the public benefits that she received as it relates to her children. Count 8 and 9 are both insurance fraud counts against Chad Daybell for making basically false claims as it relates to any monies that would have been paid from the insurance company in regards to her death. And, there's been some evidence presented throughout the time that he was the one writing checks for the attorneys for Lori Vallow. And as we now also know, Mr. Means no longer being paid by whomever, or whatever retainer was originally paid has been exhausted, and now he is representing Lori Vallow at state expense. Be curious to see what the financial arrangements are for Mr. Pryor as it relates to this particular case, because when you basically have, you're defending a 9-count indictment in regards to 3 separate murders, as they say in the legal business, sounds expensive. And because, it doesn't take less time when you have more charges. It takes more time, and you don't know how many rabbit holes are going to go down, something like that. Most attorneys aren't going to take a case like this on a flat fee basis. It's going to be, no, we need a significant retainer. We're going to bill you by the hour, and just keep making deposits in that retainer account until we tell you to stop, because it's going to be expensive, particularly if you're talking a 2 to 3 week trial in this particular case. So that's where we are. Quick recap. We're just waiting for the court to start the process, and start basically turn the camera on for all of us to watch. Everybody should be there in person but also streaming via the court's YouTube as well. So we'll see when that starts. This is not uncommon. Every time we've had a court appearance, there seems to be the start time. And just remember, unless you go to federal court, nothing starts on time, okay? I always have to tell clients, well, court says 8:30, and obviously you got to know the judge. Some judges do start on time. But for the general rule, nothing starts on time in the court system unless you are in federal court. Federal court, you can set your clock by the court schedule. In fact, most federal courts, they usually come out early. Don't know why that is, why state court judges just can't seem to get everything started on time. It's frustrating, but I get it. And as we've also had in previous court appearances, they go back into the Zoom chambers, or today they may be back in the normal chambers here for Judge Boyce, and they're working stuff out, and they'll come out and they'll keep it real simple. We've seen that before. I don't know if that's going on there because I'm not there. I wish I were. We actually had talked about it, but I had some commitments, and it just wasn't going to work out, unfortunately. I would have liked to. We still have to get a trip out there. All right, Frank, Julie, we're still going. Okay, maybe for the next one. Are we going to start? No, you're just saying we got to go. All right. And it's also unclear, obviously, if the sheriff is bringing in Chad Daybell, that he is going to be brought in. Previously, he's always appeared via the Zoom, WebEx, whatever system they're using out there, and they dress him out, which is normally quite unusual for a pretrial proceeding. Normally, a defendant only dresses out if it's trial, because who cares what they wear to court in that regard. Now, I always tell my clients, if they're going to show up for court and you're out of custody, certainly don't show up looking like you just changed the oil on your car. You'd be surprised what people wear to court. But as a general rule, you want your client to look good. And hey, if the court's going to allow it and the jail has no problem with it, good on you, so to speak, to get your client to wear civilian attire. But it's not a necessity, particularly if the matter is just going to be, a quick continuance or a quick arraignment. Who cares what the defendant's wearing if they're in custody? But it's all part of the bigger picture. And, Mr. Pryor obviously is on the ground. He knows all the people there. Maybe he figures it'll make some difference. You certainly want to have that good picture. And if your client's going to be in the paper, you might as well have him, wearing a shirt and a tie versus, wearing your striped jailhouse uniform. So I get it in that regards. So that's where things stand, like I said, as we wait here today. The arraignment for Chad Daybell, it's a 9-count indictment. Conspiracy to commit murder in the first degree as to Ty Lee, murder as in the first degree as to Tylee Ryan, conspiracy to commit murder in the first degree for J.J. Vallow, murder in the first degree for J.J. Vallow, conspiracy to commit murder for Tamara Daybell, then murder in the first degree. Count 7 is the theft count for Lori Vallow. She won't be arraigned. She hasn't even had a advisement as to the indictment because she was deemed to be incompetent. Count 8 alleges only Chad Daybell, as well as count 9, which both are allegations of insurance fraud. Frankly, that's the least of the concerns of Mr. Daybell, as obviously he's looking at life in prison on the first-degree murder charges. And, the conspiracy and the murder, same victim, those counts would merge. But if, assuming it's life without parole, all you need is one of those and you're pretty much done. Here's a tip for these wonderful mods, Frank and Julian, of course, the blood-sucking lawyer as well. Well, just Jimmy, I appreciate your humor there. So yeah, so that's, we're just waiting to see what's going on. It's not unusual. Like I said, every court appearance we've had with Judge Boyce, everything always seems to take place off camera, so to speak, and not in public. And then we do a recap, which is unusual. And maybe it's the case. I don't know. I've never appeared in front of Judge Boyce. I don't practice in Idaho, so I'm not going to say what's the norm there. Only time I've ever had a judge do that was when I was a judge advocate in the Marine Corps. The judge would always go back and we would go over everything. Everyone was this is what's going to happen, and don't deviate from it. And he wanted a nice, clean record. So apparently, the judge must have learned or got burned by something that was said on the record, and the ruling. That judge, he just wanted a nice, clean record, and. But, I think our system of justice should be done in the open courtroom. A speedy and public trial means that it's open to the public, and the public should have a right to, have access to the filings in, frankly, every case. It's public record. And, it used to be very easy. You'd go down to a courthouse and say, I want to go to the records room. You could pull any case you wanted. And today, with the digital world that we're in, there is really no paper file. And it seems like the judges suppress things that do not, frankly, need to be suppressed. For our Patreon members, we talked about, I put out a video last night because I wasn't able to do our Patreon, but I did one just for them in regards to that as well, where they run into that issue on the Barry Morphew matter in regards to the death of Suzanne Morphew. The judge isn't releasing the affidavit, and I think we'll put that video will go live, I think sometime today for everybody else, but we put it up to our Patreon members first. Jen, do you think Mark Means could have encouraged Lori to go incompetent so he wouldn't have to try the case? Jen, I wouldn't. That would be complete speculation on my part. But as an attorney cannot, what's the word I'm looking for? An attorney should not try to tell somebody to fake being incompetent. That would be completely unethical. And I don't think, even though I've had, criticisms of Mr. Means, I don't think that hopefully no one would go to that length. That would be completely unethical. And I'm not saying he was. As far as we know, apparently, listen, Lori Vallow, a motion was made. She was evaluated. She came back not to be competent. The prosecutor, with advice of their expert, confessed the motion. So I have to assume that it was all done in good faith, and apparently it was. And the prosecutor, if they thought that, she was malingering and she was faking, they could have had a hearing on it. That hearing was set for, I think, the 16th of June. More than likely it'll be vacated because she's off. As of today, I think she was sent off to the state hospital. So, yeah, I have no reason to believe that Mark Means told her to malinger or anything like that. Normally the evaluators are pretty good at trying to pick out the fakers, so to speak. I would be curious as to see what was basically the nature of the was there some sort of psychosis? They just don't understand reality, or I'd be very curious to that. She's going to be under the treatment, and, they're going to figure out what's going on. Tammy, I believe Chad and his attorneys are in the judge's chambers trying to get a deal. Tammy, the judge would not be involved in any deal that was going to be had. Deals are only, worked out between the prosecution and the defense, and the judge can reject it if they think it's too good of a deal. I've had judges do that. Never had one when they said I thought it was too harsh of a deal. But the judge is not involved in the negotiation process whatsoever. the judge just simply would say, I'm going to, if there were a plea, and I don't think so. I think they're going to. If I was a betting man, the longer we wait, the more likely there is a request for a continuance. I don't know that for sure. I'm just going on my gut here. Hopefully I'm wrong. I think this case needs to get going. The prosecutors have obviously had the evidence. They've got the indictment. The defense attorneys have had the discovery. They've known basically what is more than likely coming. It did in the form of an indictment, a 9-count indictment, trying to hold Lori Vallow and Chad Daybell responsible for the deaths of Tylee Ryan, J.J. Vallow, as well as Tammy Daybell. And, cases need to move forward. One of the things I like about criminal defense is that cases end. Sometimes it seems like they'll never end quick enough, but they end. Civil cases drag on, and they go years and years. But criminal cases, because of the speedy trial statute, cases have to get moving, and deadlines force people to make decisions. And in a criminal case, most people, if the defendant doesn't have to make a decision, they don't have to. I'll maintain the status quo as long as nothing bad is going to happen. But you have to do that. You have to do that. It forces prosecutors to make decisions as well. So we'll have to wait and see. Let's see if we can answer some of these questions while we wait for the arraignment of Chad Daybell in regards to the 9-count indictment. 8 charges actually affect him because count 7 only names Lori Vallow. Gene, Scott, do you think Melanie Gibb knew more than she's saying? I don't know. I have no idea. That's going to be interesting on cross-examination on her. But hey, that's what trials are for. Yeah, Diane, we need this case to go moving forward. It does. It's like some cases just linger, and we need a strong judge to move the case forward. Let's see, Debbie. I don't believe that Lori is insane, but I can certainly understand the courts putting her through the legitimate process and not screwed up the case moving forward. Yeah, nobody's saying she's insane. She's just not found to be competent at this time. The legal definition is you have to be able to understand the proceedings before you, the penalties, the charges, the roles of the people, what's a plea bargain, what's a trial. Pretty rudimentary stuff when it comes to this process. The question is why do they deem her incompetent? Was it some sort of psychosis? Was it basically a meltdown, so to speak? Who knows? That's going to be the interesting thing. We just have to wait and try to find out. Let's see here. Any chance guilt has kicked in and Chad pleads guilty? This from AM. I doubt it. I mean, and here's one of the things, ladies and gentlemen. This is coming from the criminal defense lawyer's side of things. I assure you, if your client is charged with 8 counts in the indictment of a 9-count indictment, and 3 counts of murder, where your client's looking to spend the rest 3 years in the rest of your years in prison, probably die in prison. Unless the client is saying, I want to plead guilty, you're going to trial. Okay? You're going to trial. Oh, here we go. We got it coming up on the screen here. Should be just a second. All right. So Chad Daybell's in court, once again, dressed out, white shirt, blue tie.
The FTR recording system. It's also being live streamed on the court's YouTube channel for public availability of the hearing. In addition, in order to allow public access, we do have limited seating here, and that's consistent with our Supreme Court's operating order for social distancing. So we do have people in the courtroom as well, pursuant to that order. Mr. Daybell, as you know, I'm Judge Boyce. I'm the district judge for Fremont County, and I've been assigned to preside over this case. In a few minutes, I'll arraign you on criminal charges that have been brought against you by the state of Idaho, pursuant to an indictment that was issued by a grand jury. Before doing so, I'll explain what will happen at this arraignment and then advise you of your constitutional rights and plea options. If at any time you need to communicate with Mr. Pryor in confidence, please advise me. We can arrange to have the two of you in a separate place outside the record of the court or anyone else and have a personal discussion if you require that during the time of this hearing. In this case, there was an indictment issued by the grand jury on May 25th, 2021, and that indictment sets forth the criminal charges that have been brought against you. The indictment's not evidence, rather it sets forth the criminal charges against you that would be prosecuted by the state of Idaho in this case. Mr. Pryor, have you received a copy of the indictment and reviewed that with your client, Mr. Daybell? Yes, Your Honor. Okay, thank you for that, Mr. Pryor. In a moment then, Mr. Daybell, I will advise you of the charges that are pending against you and explain the penalties associated with those charges. Next, I'll discuss, Mr. Pryor, your plea options and rights. The purpose of an arraignment is to have you enter a plea to the charges in the indictment. At the end of the arraignment, then you'll be asked to enter a plea. In that regard, you would have three options. Your first option is that you may enter a plea of not guilty to the charges. If you elect to plead not guilty, then a jury trial and a pretrial conference will be scheduled in this case. Also, by pleading not guilty, you would maintain all of your constitutional rights in this case, which rights were previously explained to you at an initial appearance on May 26, 2021 before the magistrate. Among those rights, you have, I'll go through some of those. You have the right to be presumed innocent. The presumption of innocence is a real and important right which lies at the foundation of our criminal justice system. Therefore, unless you either plead guilty at a later date or the state proves the charges against you beyond a reasonable doubt at trial, the presumption of innocence remains in your case. You also have the right to a speedy and public trial by an impartial jury of your peers, as well as the right to see, hear, confront, and have your attorney question all witnesses who may be called to testify against you. During the pendency of your case and at trial, you also have the right to be represented by an attorney. As you are in custody, you also have the right to communicate with your attorney at all stages of your case, and reasonable access to communicate with your attorney will be provided throughout these proceedings. At your trial, you would have the right to present evidence in your defense and the right to the subpoena power of this court to compel the attendance of witnesses to testify on your behalf. And finally, if you plead not guilty, you will retain the right to remain silent and exercise the privilege against compulsory self-incrimination. This means that you cannot be required to testify against yourself. However, you may voluntarily take the witness stand at trial if you so choose, but you cannot be compelled to do so. If you decide not to testify in your own behalf, then the prosecuting attorney could make no remarks about your failure to testify and cannot imply to the jury that exercising your constitutional right to remain silent is any indication of your guilt. The second option you would have today is to enter no plea at all. If you decide to do that, the court would enter a plea of not guilty for you, and you'd continue to maintain all of the rights that I've previously explained. And your third option at this arraignment is that you may plead guilty to any or all of the charges. However, it is important that you understand that if you do plead guilty, you would automatically waive rights, including rights under the 4th, 5th, and 6th Amendments to the U.S. Constitution, as well as similar rights contained in the Idaho Constitution. In other words, if you decide to plead guilty, you would waive your right to a trial. There'd be no trial in your case, and you'd no longer be presumed innocent. The state would no longer have the burden of proving the case against you beyond a reasonable doubt. By pleading guilty, you would also give up your 6th Amendment right to confront your accusers and cross-examine any witnesses against you, and give up your right to offer evidence of your own behalf in response to the state's case against you. You would also waive any defenses you have to the charges contained in the indictment, including any claims that there is a defect in the state of Idaho's case against you, or that you've been treated unfairly by the court. Give up also your Fifth Amendment right to remain silent and the privilege against self-incrimination. And if you were to plead guilty, you would also be required to testify under oath concerning the facts of the alleged offenses in this case to allow me to determine whether or not there's a factual basis for your plea, and whether the plea would be made knowingly, freely, and voluntarily, and to determine whether or not you fully understand the consequences of that plea. Finally, you are advised, if you decided to plead guilty, any testimony that you give while under oath concerning the alleged offenses could and would likely be used against you at a later trial if I were to not accept your plea for some reason, or if you later withdrew your plea. It is very important you understand all the rights and options I just explained to you. Before we go any further then with this proceeding, Mr. Daybell, do you have any questions on any of those rights I've just explained to you? Very well. Mr. Daybell, in this case, then you were brought before this court to answer for the indictment filed in this case, which alleges you've committed serious crimes in that 8 felony charges have been filed in the grand jury's indictment. In that indictment, let me ask you a question, Mr. Pryor. Do you have that before you? Copy of the indictment? All right. Is the defendant's name, Mr. Daybell, spelled and listed correctly on that indictment on the caption? All right, thank you. At this time then, I will go through the charges that are listed in the indictment and the penalties for each charge. After doing that, then, Mr. Pryor, I'll ask your client how he pleads. So I'll read through the list of charges first, and then I'll ask for the plea after that. Then the indictment that was filed on May 25th, in count 1, charges Mr. Daybell the offenses of conspiracy to commit first-degree murder and grand theft by deception, both felony counts under Idaho Code 18-1701, 18-4003A, 18-24031, 18-24034A, 18-24071B3. The count in count 1 names Tylee Ryan as the victim on the murder charge, and that count carries a penalty on the murder charge of it is punishable by death or imprisonment for life, and it provides that if the death penalty is not pursued by the state, then the court shall impose a life sentence with a minimum period of incarceration of 10 years. The grand theft portion of that charge has a penalty of up to 14 years of prison and a fine of up to $5,000 and possible restitution. That's a summary of those charges, and you've waived the reading of the charges. So let me ask you on that count 1, Mr. Daybell, do you understand the charge and those possible penalties? Okay. The next count in the indictment is count 2. That is a count of first-degree murder under Idaho Code 18-4001, 18-4002, 18-4003, subsection A, and 18-4004. And that count names Tylee Ryan as the victim. The possible penalty or punishment for that count is by death or imprisonment for life. And if the death penalty is not pursued, then the court shall impose a life sentence with a minimum period of incarceration of 10 years. You understand that charge and the possible penalties? Count 3 of the indictment charges conspiracy to commit first-degree murder and grand theft by deception. Those are felonies under the same code sites that were previously listed under count 1. That count names Joshua Jackson Vallow, also known as JJ Vallow, as the named victim in that count. And the penalty for those charges on the conspiracy to commit first-degree murder is punishable by death or imprisonment for life. And if the death penalty is not pursued, then the court shall impose a life sentence with a minimum period of incarceration of 10 years. On the charge of grand theft by deception, that would have a penalty of up to 14 years in prison fine of up to $5,000. You understand the charge in count 3 and those possible penalties, Mr. Daybell? Sure. Very well. Count 4 of the indictment charges you with first-degree murder, a felony under the statute previously cited, and the other counts also. That count names J.J. Vallow as the victim, and again is punishable by death or imprisonment for life. If the death penalty is not pursued, then the court shall impose a life sentence with a minimum period of incarceration of up to 10 years. You understand count 4 and the possible penalties, Mr. Daybell? All right, the next count listed in the indictment is count 5, conspiracy to commit first-degree murder. That count names Tammy Daybell as the named victim. It's charged again under Idaho Code 18-4001, 18-4003, subsection A, and 18-1701. And that count is also punishable by death or imprisonment for life. And if the death penalty is not pursued, then the court shall impose a life sentence with a minimum period of incarceration of 10 years. Do you understand the charge in count 5 and the possible penalties? Count 6 of the indictment is a charge of first-degree murder. That names Tammy Daybell as the victim. It's charged under Idaho Code 18-4001, 18-204, and 18-4003, subsection A. That count also is punishable by death or imprisonment for life, provided that if the death penalty is not pursued, then the court shall impose a life sentence with a minimum period of incarceration of 10 years. Do you understand count 6 and those possible penalties, Mr. Daybell? All right, count 7 of the indictment is not a charge against you, it's a charge against a co-conspirator. Count 8 of the indictment charges you, Mr. Daybell, with the crime of insurance fraud, which is a felony under Idaho Code section 41-293. That is a felony that carries up to 15 years in prison and a fine of up to $15,000 plus restitution. You understand that charge and those possible penalties? All right, count 9 is also a charge of insurance fraud under that same statute. It carries the same penalty I just mentioned in count 8, which again is 15 years of prison and a $15,000 fine plus restitution. You understand that charge and those possible penalties? All right, that is a summary then of the charges that have been filed against you and the penalties. I would also note those penalties in each of the counts could be ordered to be served either concurrently, meaning running together, or consecutively. And so do you understand those charges could also run consecutively in those different counts, Mr. Daybell? All right, at this time then, having gone through the counts and the possible penalties, at this point, I would ask your client how he intends to plead. Before I do that, Mr. Pryor, do you have any questions for the court or anything you need to discuss with your client before I ask for the plea? All right. Thank you, Mr. Pryor. I will go through them then individually again. On count 1 of the indictment, Mr. Daybell, how do you plead? Under the not guilty plea on count 1. On count 2, how do you plead? On count 3, how do you plead? On count 4, how do you plead? On count 5, how do you plead? On count 6, how do you plead? On count 8, how do you plead? And on count 9, how do you plead? Very well. Not guilty pleas are entered as to all the counts in the indictment. At this time, normally we would discuss a trial setting. I talked to counsel and chambers before we started, and given the nature of the case, we've determined that we'll set a scheduling conference 2 weeks from today to get a trial set. Does your client agree to a scheduling conference in 2 weeks and move to a trial setting right now, Mr. Pryor?
Yes, I discussed that.
All right, very well. Do you understand then we'll set your trial in 2 weeks in lieu of doing that today, Mr. Daybell? Okay. So we'll hold that hearing on June 23rd. Council, any suggestions on time? I'm thinking probably just in the morning at 9:30.
That works for the state as well, Your Honor. Thank you.
All right, I'll set the scheduling conference for June 23rd at 9:30 a.m. We will conduct that hearing by Zoom. That will not be a live in-person proceeding. And at that time, we will get the matter set for a trial on these counts. I believe that concludes the matters we need to bring up on this case this morning. Then, is there anything further from the state on the case today?
Nothing further from the state at this time, Your Honor. Thank you.
All right, thank you, Ms. Blake. Anything further from the defense, Mr. Pryor? You may. Thank you, counsel. That will conclude the hearing and we'll be in recess.
Okay, well, there you have it. We brought you the arraignment in the matter of Chad Daybell on the 8 counts that he is named in the 9-count indictment regarding the death of Tylee Ryan, J.J. Vallow, and his wife, Tamara Daybell. So one of the longer advisements I think I've ever been at, even in a homicide case. The judge went through each count. Then he went through each count and the possible penalties. Obviously, the first-degree murder charges and the conspiracy to commit murder carry the potential of a death penalty. And there's no indication that the prosecutor is going to go death on this particular case. And the prosecutor has, I believe it's under Idaho, if I remember reading it, if I remember correctly, it was either 45, I think it's 60 days. They would have to give notification of that. And that would change everything in regards to the timing and what have you. So I can't imagine this is a death case when you have a guy that has no, prior aggravating factors other than the allegations in this case. And understand he's obviously presumed innocent. A couple of observations. Like I said, it was one of the longer arraignments I've ever seen. Normally, the judge just says, I get it. It's a big case, so people are interested, and the judge wants to make sure he dots his I's and crosses all of his T's. But normally, a judge says, "Hey, have you received a copy of the indictment, counsel and the defendant?" "Yes, we have, Your Honor." "Would you like me to read the indictment and go over it?" And normally say, "Your Honor, we waive any further reading and advisement of the indictment." And then we'd ask the court to accept a plea of not guilty for all counts in which my client is named. But the judge went through and asked specifically for Chad Daybell's plea as to each count, and Chad Daybell entered a plea of not guilty to all counts. One of the questions that was asked in the chat where things were going by, could Chad Daybell enter a plea of guilty to one of the charges? Yeah, hypothetically you could, but why? They're looking at sending you to prison for the rest of your life. The bulk of the charges are sending you to prison for the rest of your life. Why would you do that? Hey, the government charged it. Make them prove it beyond a reasonable doubt. And maybe it's just an Idaho thing. Once again, it's an arraignment. You'd think they'd clear calendars. They were, chatting beforehand. You couldn't go back and try to clear some trial dates. So now we have another scheduling conference set on June 23rd at 9:30. It'll be Zoom. We'll bring it to you. But once again, a hearing to set a trial date. We set more status conferences to set future court dates in Idaho than I've seen in most jurisdictions. But to each their own. They're trying to dot their I's, cross their T's to make sure they get it right. One of the things in the courtroom is you saw at least 4 deputies in the courtroom. Not necessarily unusual. I'm sure they have beefed up security just given the high profile nature of the case. But there's always a deputy, 1 to 2, whenever you have a defendant in custody. So I wouldn't take a whole lot from that. He's not some risk or danger to the community as far as trying to escape, but you never know. The other observation, it appears as though Chad Daybell's children were sitting behind him. One must assume if they were sitting behind him that they were there to support him and do not believe that he killed their mother. So that's always interesting. We have that as we've talked about the Barry Morphew matter as well, where the children are standing behind their father, sitting behind him at the court appearance. Now, one other thing the court did go through, and I think it's always worth mentioning, the court gave basically a general advisement, and he told Chad Daybell that you have the presumption of innocence, and unless and until you either are found guilty or you enter a plea, that presumption of innocence would remain with you. All right? Who has said that, right? These are fundamental constitutional principles, ladies and gentlemen. We just don't make it up to make things difficult. These are in the Constitution, all right? The judge advised him he has a right to a speedy and public trial. He has a right to confront and cross-examine through his counsel all witnesses that are called, to examine all evidence that is being produced against him. He has a right to counsel, obviously. If he couldn't afford counsel, they would appoint him an attorney. You have a right to subpoena witnesses, to call witnesses in your own defense, to produce evidence. They wouldn't come voluntarily. You could subpoena those witnesses. You have a right to testify, and no one could compel Mr. Daybell to testify or not to testify. That's his own personal decision that he would have to make at the time. He doesn't have to make that decision at all. Additionally, if he chose to remain silent at trial, which is his constitutional right to do so, a very personal decision for him to do so, then the judge would instruct the jury that they could not consider or use his silence against him any way possible. Additionally, if he went to trial and he was convicted, he would have a right to an appeal. And if he were to plead guilty, the judge also advised him of pleas that if he pled guilty at some point, you'd be given up your rights. So there'd be no trial, there'll be no confrontation, there'll be no jury to decide whether the prosecution has proven each and every element of the offense beyond a reasonable doubt. And there would be no basically challenge to the government's evidence as to the legality of it or the sufficiency of it if one pleads guilty. And there certainly wouldn't be any appeal if one ever pled guilty. Now, these are good things that the court advises everybody of at some point, and obviously the attorney for the defendant goes over that with their client as well, because let's face it, most people just don't know all the rights you have unless and until you get in trouble. And then everything's going on, and you got to hear it a couple of times until people really start to get it. And the court did state that if there's going to be a guilty plea, you would have to tell me in your own words what you did so that I could be certain that there was a factual basis for the guilty plea, all right? Most courts, particularly in homicide cases, don't allow what they call an Alford plea, which is saying, well, I'm not saying I did, I'm not saying I didn't, but I'm accepting the deal. Most judges don't want people to plead guilty to something they didn't do. So the judge will tell them or ask them, tell me in your own words what you did, and the judge would have them admit the elements of the offense on the record, make sure it's knowing, voluntarily done, and that is what a defendant wants to do. So the court went through all of those, like I said, dotting I's, cross the T's. Sometimes it's done in the form of a paper. The clerk says, here, fill this out, have your client review it and sign it, initial it, and obviously the attorney does it. This was a little more formal. I get it. Big case. Judge wants to make sure everything's done right. And then, like I said, Chad Daybell was asked as to each count, how does he plead? He enters the pleas of not guilty. That starts that speedy trial clock of 6 months. And they set a status conference on June 23rd at 2021 at 9:30 to actually set a trial date. We'll bring it to you. And remember, unless there's some agreement to stop speedy trial, then the trial must be commenced no later than December 9th. So that would mean, a trial early fall. Wouldn't that be fun? Ooh, I hope so. And of course, it doesn't stop the other trial as it relates to the tampering with evidence that's still pending. The question will now become, will the prosecutor move to join those cases, which would seem to make sense because there's a logical connection, right? You have the conspiracy, the charge, the allegation of murder and conspiracy to commit Tylee, JJ, and Tamara Daybell. It would make sense to be able to tell the rest of the story that they found the remains of JJ and Tylee on his property. Oops, that could be a problem, right? Unless, of course, you say, I had no idea. Alex Cox must have done this. I have no idea. So more than likely, there'll be some sort of motion to join. I would anticipate that as well. We'll see, at the next date, there'll be a scheduling order. The judge will then lay out when motions will be due and when responses will be due. They'd set a motions hearing date to resolve legal issues in the case, what evidence comes in, what challenges come in as it relates to the veracity of the, any search warrants and things of that nature. And then ultimately a trial where a jury of 12 peers would decide the question of fact. Did Chad Daybell, along with a conspiracy of Lori Vallow and Alex Cox, conspire to commit JJ and Tylee Ryan, JJ Vallow and Tylee Ryan? Was he involved in the murder of each of them? Did he commit insurance fraud? That's what juries decide. The judge at this point will be the decider of the law. They'll make legal rulings, and the jury will decide questions of fact. Did this happen as alleged by the prosecutor? So, all right, hopefully that's a quick wrap up. Thanks for joining us. We'll have a video up later today, so please join us. If you haven't done so already, please subscribe, hit that like button, hit that little bell so that you receive notifications of when we go live just like this, because it was uncertain whether it was actually going to be available for us to put out there for everyone. So I want to thank everybody for doing that. Follow us on the Instagram, Facebook, Twitter. Anything else I'm missing? Anyway, I don't think so. Have a wonderful day. We brought it to you live. Thanks for watching. We'll see you next time on Crime Talk.